Merchant Shipping Act 58 of India refers to the casualties as shipping casualty. In the Merchant Shipping Act, they don't refer to marine casualty, they refer to it as shipping casualties. So what are these shipping casualties? Let us look at them. The administration says that these casualties will be investigated by the procedure which is stated in Chapter 12 of or Part 12 of Merchant Shipping Act. But considering that the basic objective of CIC is to find out the root cause and to find out if any alteration to the existing regulation should take place or the accident should not happen in future, the Chapter 12 or Part 12 of Merchant Shipping Act has got the same objective. But in addition to these objectives, the Merchant Shipping Act, in compliance with paragraph 1 to 6 of Article 94 of Unclause 82, has to do many other things, many more things. So that we will see when we study in detail the preliminary inquiries and formal investigation in case of Merchant Shipping Act. So section 358 of Merchant Shipping Act says that in order to do the investigation under this part, the shipping casualties will be one of the following. So A is on or near coast of India, any ship means Indian ship as well as foreign ship, any ship is lost, abandoned, stranded or materially damaged. Point B is on or near coast of India, any ship causes loss or material damage to another ship. The paragraph C once again is on or near coast of India. The loss of life ensues because of any casualty that happens to a ship or on board ship. This means any ship, regardless of the nationality, when that ship is on or near coast of India, any of such things happen, whether the ship is abandoned or whether there is collision or there is a loss of life that ensues on the ship. All these matters will come under shipping casualty. Now this paragraph D and E are in respect of Indian ship in foreign water. So if there is a similar loss, abandonment, material damage, etc. of a ship, or there is a casualty that happens on the ship, that means death or serious injury that happens on the ship, and the competent witness is found in India, then such incident will be called shipping casualty. Now paragraph E is when Indian ship is lost or supposed to have been lost anyway. And then when efficient evidence is found in India in respect of the various circumstances, like in respect of sailing of the ship, when was the ship last heard of, when did the ship depart from the port, if any witness or evidence is found in India, then this incident also will be considered as shipping casualty under section 358. So in the first three cases of any ship on or near coast of India, the master, pilot, harbor master, etc., whoever is in charge of the ship, they should report the matter to the officer who is appointed by central government in this respect. And in the later two cases, the master of the ship concerned, when he reaches India, immediately has to inform the officer who is appointed by central government in this respect. Now sometimes you are questioned that in the definition of shipping casualty as provided in Merchant Shipping Act, there's nothing talked about oil pollution. First three cases are in respect of any ship, and we have seen last two cases about Indian ship anywhere. But it does not talk about, it does not directly talk about oil pollution. So whether we should report it, whether the oil pollution should be reported or not. Oil pollution is not directly talked about, but if we talk about material damage to the ship or grounding of the ship, it indirectly will have a byproduct called pollution, right? Pollution could always occur in a materially damaged ship or a grounded ship. Moreover, if you look at point number 7 of the definition of marine casualty as defined in Casualty Investigation Code, it talks about severe marine pollution or potential for severe marine pollution. And India conducts inquiry into the casualties as envisaged in Casualty Investigation Code. That means in India, the investigation in respect of casualties will also consider the definition of casualty which is there in marine casualties. Moreover, IMO wants that all the emergencies, including the marine pollution, all the emergencies that could occur on the ship should be identified. There should be a uniform or a standard procedure of attending to or addressing these emergencies, and details should be mentioned in SMS of the ship. The idea of integrated contingency planning is all the emergencies are dealt in a uniform manner so that the time lost, very important time lost in deciding what is to be done, is not there, and you can efficiently attack an emergency. Right? So marine pollution is also one of the emergencies, and all the ships, they are supposed to inform the various entities outside the ship. And two of the very important external entities who must be informed about the emergencies are Coastal Administration and the Flag State Administration. So considering that also, that the pollution is one of the important emergencies which has to be addressed in the SMS of the ship, which means according to the integrated contingency principles, marine pollution is an emergency which should be reported to flag state as well as coastal state. Now if you look at the definition, considering the lighter part of it, if you look at the definition of wreck in Merchant Shipping Act, any floating goods which are thrown from the ship or which fall off from the ship would be considered as wreck, and wreck must be reported. There is a mandatory requirement in respect of reporting the wreck. Now here I will also refer to this section 356J of Merchant Shipping Act, which is the power to give notice to the owner in respect of oil or noxious liquid pollution. Now here is the section 356K, which is power to take measures in respect of pollution by oil or noxious liquid substances. You cannot do away with reporting. Reporting has to be done in respect of any marine pollution. If you look at Article 8, which is incidents involving harmful substances polluting, it says that every incident has to be reported to the fullest possible extent and immediately. Administrations have to take care that they have appropriate agencies or officers who are capable and who will be able to receive the report, process the report and analyze the report. Then these reports have to be sent to IMO with fullest possible details. Regulation 37 of Annex 1 of Marpol 7378 is SOPEP. As per this regulation, every tanker of 150 gross tonnage and above, and other ships which are of 400 gross tonnage and above, they should carry a SOPEP. SOPEP is the plan in respect of oil pollution or any emergency related to oil polluting the sea, etc. Regulation 17 of Annex 2 of Marpol 7378 makes similar stipulations, and as per this, every ship of 150 gross tonnage and above should carry a plan that is called SMPEP, that is Shipboard Marine Pollution Emergency Plan. Now the contents of this plan, now both these plans, whether it is SOPEP or SMPEP, they should be approved by the administration. So both these plans have similar stipulations, similar contents. So they say when you have to carry both the plans, might as well carry one plan under SMPEP, that is Shipboard Marine Pollution Emergency Plan. Now both this SOPEP as well as SMPEP, they should have an appendix whereby the list, contact number, etc. are put of all the agencies or offices which can be contacted subsequent to a marine pollution or incident like this. Right? So it will be called NOPC. NOPC means National Operation Contact Points. MS rule in respect of prevention of pollution by oil, as well as MS rule in respect of prevention of pollution by noxious liquid substances have the similar provision. Now talking about an officer who is appointed in this respect, in respect of pollution, right, by the central government. Now when he receives this report, he shall make a report to the central government, and he may proceed to conduct preliminary inquiry. As he does the preliminary inquiry, he is supposed to send the report to central government, that is the DG shipping, in respect of the pollution. This section is not very clear in respect of what is the procedure that should be followed. standard operating procedure dated 15th March 2022, and that is in respect of how the preliminary inquiry should be conducted. So after receiving the information from DGS, the principal officer of jurisdictional MMD, he will appoint an officer to conduct the inquiry, and he will be called inquiry officer. Now this inquiry officer additionally should inform DGCOM center. Now DGCOM center can get the information from the party concerned if they want. Now this nominated inquiry officer will liaise with Casualty branch of DG Shipping and also coordinate with various parties, including the master, owner, operator, charterer, and insurer, etc., in respect of whatever matter they want to discuss or whatever information has to be acquired in respect of various things associated with the incident. Also, the jurisdictional MMD, in concurrence with the Casualty branch of DG Shipping, can issue the notices to the ship owner as provided in section 356J of Merchant Shipping Act, and also act in accordance with section 356K of Merchant Shipping Act. The inquiry officer has to commence the inquiry as soon as possible. For that, he may have to visit the site, that is the ship, or he may have to board the ship. So he'll be allowed to board the ship. Such officer or the officer nominated under section 388 of Merchant Shipping Act may be accompanied by the personnel who may be taken to the ship in order to, say, dismantle something, remove an equipment or part of it, which is necessary for conducting a preliminary inquiry. The inquiry officer or the other officer which is nominated, as I said, under 388. Section 388 means a person who might be aware or more conversant with the technical details of the cargo which is there on the ship. For example, if there is a chemical tanker on fire, if the chemical that was instrumental in causing the fire, you might have a person who's PhD, who's a professor of chemistry, who knows more about the chemistry or working in the industry and dealing with the chemical products, etc. So that person can be appointed as a special officer under section 388. So these people, when they go on board, they can enforce the production of the documents such as logbook, official logbook, the certificates of the ship, the VDR information, or the information in respect of the communication which is made by the ship, the medical records, the P&I insurance, or the hull and machinery insurance plans, etc., etc. So all these documents may be required to be produced to such a preliminary inquiry officer or the special officer who's appointed. The inquiry officer or the other officer, he may require the attendance of people on board, certain personnel on board, in order to conduct the preliminary inquiry or to reach at a certain conclusion. For this purpose, the information in respect of attendance may be provided formally or informally. If a person that is required to attend, if he does not attend, then summons can be sent by these officers. And in case they still don't appear after providing the summons, then the investigation officers, in concurrence with the principal officer of the port, they might file a complaint in the court of judicial magistrate of first class. And then these inquiry officers, they are authorized to administer the oath. The inquiry officer can examine and he can take statements in respect of preliminary inquiry from different people. So as far as the post inquiry documentation is concerned, there are two types of documents. One is the preliminary inquiry report, and other one is the recommendation of preliminary inquiry. That means after the preliminary inquiry, what are the recommendations made? So the first part, talking about the first part, preliminary inquiry report, it has got various constituents. Say, number one, background of the casualty, right? And then description of the casualty, talking about the narrative and various other aspects of the casualty. Third part is the vessel details, including the classification society, and then timeline. What is sequence? What is the sequence of casualty? What is the sequence that led to the casualty? And then next you have the post casualty development, right? Then causal factor investigation. The next is the conclusion that is drawn of preliminary inquiry, and the next part is the signatures. Now the preliminary inquiry has to be completed as soon as possible. So for that, in standard operating procedures, they have given a timeline for completion of these reports. For example, initial report 3 days, interim report 30 days, and preliminary inquiry or preliminary investigation report 90 days, and then recommendations of preliminary inquiry 90 days. So this is how standard operating procedure explains how the preliminary inquiry should be done, how there is this involvement of investigation officer, a special officer appointed under 388, the principal officer of the jurisdictional MMD, and then DG Com Center, and then central government, that is DG Shipping. Now under section 360 we see the preliminary inquiry may be conducted in a particular case, or sometimes if the central government, if so desires, may write an application to the court that the investigation be directly conducted by the court. So the central government can apply to the court to do the formal investigation in case that court is empowered in this respect, either bypassing the preliminary inquiry or subsequent to the preliminary inquiry. We will see what happens in the formal investigation and what happens in marine board investigation outside India, but in my next video.